Well, we're opposite the Tate Modern, one of the most iconic UK landmarks. Over 500,000 people visit the Tate Modern every year. It's renowned for its exhibitions and artists. And you may have heard that it's been in the news recently, but not about the Tate Modern itself and its exhibition or artists, but because of a long-running dispute with its neighbours at the neo-Bankside development adjacent to the Tate Modern. I'm Dan Blake. I'm a Senior Associate at Quastels in the Litigation and Dispute Resolution Department, and I have a specialist interest in property litigation. So what's this all about? What happened? Well, back in 2016, the Tate Modern opened a public viewing gallery. They invited the public to come and enjoy the panoramic views over London. But not everyone was happy. Those tenants at the neo-Bankside development were up in arms. The premium prime properties that they paid for, offering the panoramic views themselves in their flats over London, it was an intrusion of privacy. People were able to peer in. They weren't happy. They issued legal proceedings. The case was heard in the High Court of England and Wales. So the High Court had determined that in this case there wasn't a private nuisance. So what did they then do? Well, in the senior courts of England and Wales, we have three effective branches. You have the High Court that I've just spoken about, and above that, you have the Court of Appeal, and at the very top, the pinnacle, the Supreme Court. Well, they had one final opportunity, the appeal to the very top, the Supreme Court, and they did. So all eggs in one basket, effectively, appeal to the very top. And what did the Supreme Court determine? Well, the judgment that was handed down last week made for very interesting reading, taking away and moving from what the High Court and Court of Appeal had determined, that there hadn't been a nuisance. Indeed, the Supreme Court said this was a straightforward case of nuisance, and that an intrusion of privacy absolutely can amount to a nuisance where there's been a substantial interference with the enjoyment and use of the property. And that was what the Supreme Court found. From a factual perspective, looking at it, they said you have 500,000 people every year that are coming to that viewing platform and peering directly in, able to see straight into these people's properties. How could that not amount to an invasion of privacy? And indeed, many people that viewed from the gallery would go and post on social media pictures from the inside of their homes. So they said the reasonable person would have to determine that this was a case of invasion of privacy and a nuisance. In fact, I think they used the words, it was like living in a zoo. Their lives are constantly in the public domain. So the Supreme Court found in the claimant's favour at last the final opportunity that the claimants had, and they succeeded. The Supreme Court, for now, has bounced a determination to the High Court, so they have asked the High Court to determine what's the appropriate remedy. Is that going to be damages? Is it an injunction to prevent them from using that gallery? We will see. But that decision has been made. This invasion of privacy can be a nuisance. So what does that mean for us now moving forwards? Well, from my perspective as someone involved in property litigation, I imagine this decision is of concern to many people, say particularly in the first instance, property developers. They have their plans, they're thinking ahead, or even for existing developments as to, are we going to potentially now have an issue overlooking? Is there going to be a concern of nuisance? What about impact of rights of light? Are we going to have to compensate people? Well, if we sort of strip this back, from my perspective, I actually don't think this case, for now, is absolutely going to change the landscape. The Supreme Court has reaffirmed the law of nuisance. They haven't gone and changed what constitutes a nuisance and the tests. It's a reaffirmation. They effectively said that what the High Court and Court of Appeal did was wrong, it was flawed, and that if it's ordinary use and occupation, the ordinary use that of the property, it's unlikely to be actionable. So I would say it's unlikely to change. I don't think that you're going to see a plethora of cases being brought. So I think property developers, they have to be mindful. Tenants also be mindful of what this judgment means and think about it in the context of your future plans. But do I think that we're suddenly going to see those proverbial floodgates open? Well, not at the moment, I don't.